Hello, and welcome to today's Crossfire video on the topic of escrow funds. I'm Jim Lyons, Chair of the New Hampshire Association of Realtors Risk Management Committee. I'm joined by Attorney Matt Johnson of the law firm of Devine Millimet in Manchester, New Hampshire. Attorney Johnson is legal counsel to the New Hampshire Association of Realtors. Recently, issues and concerns regarding escrow funds have been more prominent at the New Hampshire Real Estate Commission, our legal resource line, and our OMSPITS program. So Attorney Johnson will provide us with a better understanding of what you need to know about escrow funds and the interpleader process of the New Hampshire Purchase and Sales Agreement. Matt, both the Code of Ethics in Article 8 and the New Hampshire Statute 331A13 deal with escrow funds. Can you provide us with details on both?
Certainly, and Jim, thanks for having me. I agree, this topic has become more heightened. I've seen more requests for discussion about this on the legal resource line. Given that the market's hot, there's been lots of competition for listings and there's been increased disputes. So Article 8, as realtors, you're governed by the Code of Ethics. Article 8 just specifies that at a general level that any funds you receive from the buyer or a third party needs to be held in a separate and distinct account, and then leaves it to state law to get into the specifics. In New Hampshire, that's 331A13 that governs escrow accounts, that says it needs to be in a separate account from your operating account in a new institution located in New Hampshire. It does actually allow you to put it in an interest-bearing account, but if you put it in an interest-bearing account, you have to pay that interest over to the person who put the funds in, absent some other understanding. The more important subject is that statute talks about one procedure, and we're going to talk about it, but I'm going to tell you right now I don't recommend it, but one procedure by statute to deal with escrow deposits. And that says if a principal broker holds an escrow deposit for 90 days after a transaction was supposed to close, and there's been no resolution by the parties, either a release, a discharge, some agreement as to what happens with the money, that principal broker can send certified letters to both parties advising them of who the money is going to go to and give them 60 days notice. The thought being that in that 60-day window, they'll either file litigation themselves or they'll come to some agreement or they'll send a form dictating how the money needs to be distributed. Because remember, you cannot release the money normally without a signed writing by the parties telling you what to do. So the hope is that that process will work. The reason I don't like this process and don't recommend the process is there's a sentence at the very end of this provision that says nothing in this statute, nothing in this provision protects the principal broker from civil liability. So I do not recommend that a principal broker pick and choose who should get an escrow deposit back or how much of it when there's dispute, because you're opening yourself up to civil liability.
Good, great information. Section 16 of the Purchase and Sales Agreement, Matt, deals with escrow funds, everyone knows, and liquidated damages and the interpleader process. Can you speak to that provision and perhaps provide us with a recommended approach to escrow disputes and issues? Absolutely.
Yes. So I believe that the appropriate approach for a principal broker, if there is no resolution by the parties as to what to do with the escrow funds, is the common law interpleader approach. That approach applies to not just real estate transactions, but interpleader basically means you, a third party, are giving money into property or some money or property into the court and saying, court, I possess this money, but it's not mine. I make no claim to it. Here are the two or more claimants to the property. Court, you decide who gets it. And so what can happen is you can file a pleading with the court, tender the money to the court. Normally, the court will hold an early hearing and often excuse you, the interpleading party, from the case and just let the two parties that have the dispute over the escrow deposit battle it out in court, and the court ultimately will make a ruling. And at that point, you are out of the process. There is law in New Hampshire that says you can get out of the interpleader funds a portion of that to pay the legal fees you incurred to file the interpleader. And because that right exists, it's not guaranteed, but it's an option. I encourage principal brokers to write a letter to the parties threatening to file the interpleader action and advising them, if you do, you are going to ask the court to get your legal fees paid out at interpleader, which is just going to deplete the funds available to the parties, with the strong message, parties, you need to figure this out and come up to some resolution in writing as to how to distribute this money. Give them a deadline and see what happens. I've had success for clients doing that approach. And if you've done that approach and the parties still won't agree, and you go before the court's pretty willing to give you the attorney's fees, because you can establish you've done everything possible not to be there, but the parties can't agree, and therefore you're forced to get a resolution and forced to get a court order. So that's my recommended approach for escrow deposit, because that does protect you from civil liability, because you either get an agreement from them or you get a court order indicating how the money is going to be distributed, and the court will actually distribute it, not you, because you will have given the money to the court. So that's my recommendation. That's the best way to handle it.
That's good. I've actually, in my practice, only had that interpleader process come up once, fortunately, but that was some time ago. But my experience was that it was very lengthy. Many times parties look at that and think, okay, it's going to be 1, 2, 3, and in a month I'll have the money. In the case that I was involved with, it took probably better part of 2 years. And by the time everything was done, the parties ended up with a negotiated agreement, and there wasn't much left because attorney's fees had been accruing. So I don't think it's the most practical approach, but I think sometimes parties, buyers or sellers, think, okay, if we go down that road, that it's going to be very expedient. And it's probably less expedient today than it had been in the past.
It's not necessarily expedient, but from the principal broker standpoint, the reality that you just outlined is what you want to put in the letter to explain to the parties that you're essentially left with no choice. I'm going to have to go put this in the court. That's going to be time consuming, expensive. Parties, yet again, please work this out by yourself. Otherwise, I'll put it in the court, and the court will work it out, but you may not like the result. There may not be much money left by the time the result is reached, and you're going to be stuck in a court case about it. So I've had some success breaking the logjam of the parties by sending that type of letter. But sometimes the parties need to go to court, and the advantage of that process is the money gets out of the hands of the principal broker. It goes to the court, and so the principal broker really no longer has to worry about it, because once you've filed the action, you're really not a party to the case. You have no claim to the money, so you just want the court to say who gets it.
Thank you. Well, that's very insightful and interesting information. Hope it's of value to everyone, and thank you for joining us today. And thank you, Matt, for the great coverage. Appreciate it. Thank you. Bye-bye.